of jury trials, and the breakdown then under the habeas corpus of the Star Chamber.
How was one guy able to do that?
Sorry?
How was one guy able to do that?
He was able to do that as the people of England had empowered this federal council, of which Oliver Cromwell was in charge of. And there was a division within England. Once habeas corpus had been signed off, there was the Scots were behind King Charles, and in fact what they were trying to do was establish Catholicism. That's the Vatican. The Vatican was trying to impose their will and take over England. And this,
what we got now?
yeah, in fact we have. And Rabbit is a good example of that. Tony. Mad money.
So how can we apply what that guy did with our current situation?
Well, we can, and in fact I believe that through our sovereignty, which is established well and truly in law here in Australia, one of our researchers, Peter Gargan, and myself, back in about 2004, we, with our study of the law, we formulated a way of stamping our authority within the system. And we came up with a term called Commonwealth Public Official, which is documented clearly throughout Commonwealth law. In fact, when you go to, and we've got to thank Paul Keating for this, Paul Keating established the Commonwealth Criminal Code Act 1995. And in there, at the back of that act, is a dictionary. And that dictionary has the meanings of Commonwealth Public Official, and it goes from A through to Z, describing all of the people within the bureaucracy who fit that bill. Now, under section R of that, it says any person who is acting under an Act of Parliament can claim that title. And I think it's under section 147 of the Commonwealth Criminal Code Act. No person can hinder you in performance of your duties as a Commonwealth public official. Okay. You have protection under Commonwealth law to use Commonwealth law to enforce Commonwealth law and use the courts to do this, in particular the federal courts. And those acts of Parliament are sections 13 and 15F of the Crimes Act Commonwealth 1914, and basically it says that under sections 13, any one of us can drag anybody in for a criminal matter in breach of any law of the Commonwealth. And section 15F allows us to bring anybody into the courts regarding a civil breach. So those two sections are our door to upholding Commonwealth law.
So shouldn't we be encouraging all of us to become CPOs?
Yeah, we want CPOs, and what we've been doing is we've drafted a one-page document. That one-page document needs to, we feel, to be authenticated within the system. There are 2 steps to doing that.
Sorry, what?
Sorry?
You talk about the system, what?
Well, the system that currently exists today, but this system is saying in one sense, oh yeah, we are your representatives. And in one sense that is correct. They are. And a lot of them are under that illusion. But they are also, unknowingly to them, they are under a foreign influence. But we empowered this form so that it could be signed off by a notary public. A notary public that was established back in King Henry VIII's time as in effect, a court. It's a court within the Supreme Court system. And rather than go through the processes of the court, you can go to a notary public and just plead guilty and cop a penalty. And that was under the old system. They have been shifted recently, and all notary publics were answerable and appointed by the Archbishop of Canterbury. Now, it was about the time that we drafted this document that they took it away from the Archbishop and they gave the job of appointing notaries to the Chief Justice of the Supreme Court of New South Wales, which wasn't exactly according to law, but anyway, there are still a lot of old notaries around that look at that document and they just go, wow, this is fantastic. This is really a way of establishing ourselves as prosecutors and having the full protection of the law behind us.
We are anyway.
We are anyway, but this, when this has been presented to the courts, and it has been presented to the courts all around Australia, and judges have just been, they don't know what to do with it. They really do take a step back because they are hindered by the law that they recognise.
I've seen them ignore it, Darren.
So it's a way of fighting fire with fire. But we need support. You know, one single person running in and using the CPA status is vulnerable to a certain respect. But what this document does do, it puts the onus on you to understand what is in that document. It's not just for anybody. And this is something that has been abused in the past. And one individual who did abuse it suffered for it. Okay. So we only encourage this for those who are prepared to take that next step. But believe me, the law is there to protect you totally. And my experience, it's only positive with respect to the court.
You run that back, finally, what you said earlier about the CPA going in and arrest a person who's committing a crime against...
I didn't say arrest, I said bring about prosecution.
Bring about prosecution.
Yeah.
Now, that person that's going to be prosecuted, he's got to be committing a crime against a human being.
Yeah, you allege that's the case until proven otherwise.
Poisoning their water.
Yeah,
I ain't getting involved.
Yeah, I mean, yeah.
If when you're backing out, you're leaving it up to the door to stop the kid, aren't you?
Yeah, I mean, yeah, fluoride's a debate that we
It's not the
know.
fluoride I'm going to talk about,
Yeah.
it's the other components with it.
Yeah, fair enough.
The lead, the mercury, the cadmium, all
Yeah, but like I've said, Cole, the only way to fight fire in that sense is with fire. And we have established that method.
So if you're fluoridating their water?
Then they are more than happy to run that argument. Okay. So we can knock this whole thing out very quickly using their own system. And you've got to, like I said, you've got to fight fire with fire. So you've got to put on the hat that they're wearing, and with the knowledge that we show and has been established in law, and you win over them very easily.
So you're locking the chain on the arse.
Absolutely. I mean, you've got to really.
What we want you to do is when you go to court, shut up.
Yeah, you've really got to have a solid lady there.
What did you mean by foreign influence?
Okay, foreign influence. We'll go to section 44I. Okay. Okay, disqualification. This is relating to a member of
It's the
Parliament.
Commonwealth Constitution.
This is out of the Act to Constitute the Commonwealth of Australia, 63-64, Chapter 12.
The reason why it's there is because of the fine, isn't it?
Sorry?
Isn't 43 about £100 a day fine?
44. 44, any person under subsection 1 is under any acknowledgement of allegiance, obedience or adherence to a foreign power, or is a subject or a citizen or entitled to the rights, privileges of a subject or a citizen of a foreign power, if we scroll down further, we'll see that they are disqualified from sitting as a member of Parliament. Shall be incapable. Okay. Now, where's that foreign influence come from? Well, if you go right through this constitution, as I have and many others have, you'll find that there's no reference to a political party. Okay. The Commonwealth Constitution establishes the representatives who sit in the lower house and in the Senate as being representatives from the states and of particular electorates. First and foremost, their allegiance is to their constituents. Okay, so they're there to hear and to exercise the will of their constituents. The political party, because it's not defined and it's not annotated in this constitution of the Commonwealth or any of the states, has to be seen as a foreign power. Because the will and the policy of that party overrides the will of their constituents. And this is wrong. It's a foreign power. Again, this comes back to interpretation. In my study of the law, this is how I read it. Is there anyone that differs in that?
Darryl, what about the 1977 Commonwealth referendum on Senate casual vacancies, which is section 15 of the Constitution, and the people said, because the word said political party, they said, yes, we want a political party under our Constitution.
That's correct. Yes, you're so right, David. And this is where we have been so used and deceived by these people. They saw
Better
this.
explain that, Darryl.
They saw in 1977, again, this is Whitlam doing this. They saw a problem. They saw the fact that political parties weren't part of our constitution of the Commonwealth. So they thought, how are we going to bring this in? Otherwise, we are vulnerable under section 44I, and the whole lot of us are out. So how do we fix this? And they got through, out of 46 referendums that have been held in Australia since 1906 to 1999, only 6 have received a yes. Unfortunately, that question was one of them. And they used that question against us, and they inserted the 2 words political party into section 15 of the Commonwealth Constitution.
Darryl, that would have been Malcolm Fraser, not Whitlam in 1977?
Yes, it was, but this Fraser was no angel. He was basically implementing what Whitlam had already done, because these are people who were trying to influence our government system under the heading of a criminal organisation. And in fact, if you want to go back to the real crux of it, it happened in 1970 in New South Wales when Abe Saffron, who owned a whole lot of casinos and brothels throughout Sydney, was walking into the Premier's office every Friday with a brown paper bag with $5,000 in it, making sure that the government legislated according to what he wanted and his friends. And really that influence has not dropped off to this day. We really need to wake up.
Darryl, are we going to have a bit of a report on cases?
Yes, we will.
Should do that.
Okay, we'll have a report on cases, then I'll have one of our researchers has done a very good paper, and I've got copies here for those who want. I've only got 30 copies on municipal council rates. Very interesting. There's a gentleman actually wanting to get a class action in that sense. So I'll pop onto the cases. The other day in the County Court in Victoria, a lady by the name of Kathy Paneer, who is a qualified naturopath, and she was charged under the Health Profession Act 2005 for using the word specifically acupuncture on her website.